Whether COVID-19 outbreak constitutes force majeure and excuse non-performance of commercial contracts will need to be determined based on the language of the force majeure clause of the particular commercial contract. Having said that, recently the Ministry of Finance came up with a memorandum where it clearly indicated that a disruption of supply chain due to the spread of the COVID-19 virus would be covered under the force majeure clause. Having said that, this was a memorandum clarificatory in nature, and it's not a binding document for the purpose of interpreting this term in every kind of contract. Therefore, what needs to be determined for the purposes of the particular contract is the language that the force majeure clause provides for. The force majeure clause in the instance case would need to indicate whether the current pandemic falls within the force majeure clause, whether the current pandemic affects the performance of the contract. The Supreme Court of India has also laid down the principles governing the interpretation and how the force majeure clause will need to be construed. It has indicated that the force majeure clause has to be narrowly construed, and it is only when the fundamental basis of the contract is dislodged by the supervening event, in this case the pandemic, can the defense of force majeure be taken. Therefore, it becomes very imperative to examine whether the obligations of a particular party could be completely not achieved as a result of the ongoing pandemic. If that be so, and those parameters are met, then it could be concluded that yes, COVID-19 is a force majeure event for the purposes under the particular contract,